The decision of the French Court of Appeal today is the continuation of a long odyssey of injustice. It's not only that, it flies in the face of the existing evidence. You'll recall that this is a case in Canada that was based on a sheer opinion, a handwriting opinion, that the world's leading experts all unanimously agreed was completely unreliable. You'll remember as well that this is a 40-year-old investigation into an event in Paris in 1980 for which the French have never been able to attribute decisively responsibility. So French authorities have been under pressure from a powerful lobby, and they ultimately came up with two so-called expert handwriting opinions saying that a Canadian university professor was the author of the printed hotel registration card that the real bomber in October 1980 registered with in a hotel in Paris. It was then exposed during the course of the Canadian extradition proceedings in court that through international handwriting experts, that the so-called French experts didn't realize they were actually using to compare with the printing on the hotel card the wrong person's handwriting, not Hassan Diab's at all, but a woman. And they unwittingly identified a woman in California as being the bomber, who was described by hotel personnel as a male in his mid-40s. Hassan Diab, by the way, was 26 years old in 1980. Rather than collapsing the case, and encouraged, I might add, by a Canadian Department of Justice lawyers, the French sought to recruit a replacement handwriting expert. And this third expert, one Ms. Bissotti, conveniently opined for the French that the only, that indeed Hassan Diab was the author of the printing on the card, and this became the only evidence justifying extradition from Canada, so that Dr. Diab spent 3.5 years in solitary confinement while investigators in France continued to investigate the case. It turned out to have been an extradition for investigation contrary to law, rather than an expedition for trial at all. Despite the leading experts from Canada, the United States, United Kingdom, and Switzerland, all giving evidence that this handwriting opinion was completely unreliable because it used improper handwriting identification methodology, and the writing was not amenable to identification, being block printing. The evidence was held by a Canadian court to be reliable enough to deny a Canadian of liberty. He was sent to France. Back in France, with this expertise being criticized by international experts, French authorities asked a fourth and a fifth handwriting expert in France to come up with yet another report comparing Dr. Diab's handwriting with the printing on the card. These fourth and fifth experts have recently completely agreed with the defense experts that testified in Canada that the report of Ms. Bissotti, on which Dr. Diab was extradited, is completely unreliable. Dealing with the scientific methodology, in their report, they talk about the scientifically inadequate methodology for assessing similarities and differences. And then they set out the critique, which was lengthy, of the international experts. Their opinion: we are in total agreement with the defense experts. They also agreed with the international experts that what Ms. Bissotti tried to do was compare different types of block printing and cursive writing that cannot be compared. They called this trying to compare incomparables. For a number of reasons, her report and conclusions are wholly unreliable, even according to France. So after 3.5 years of further investigation with Dr. Diab languishing in a French maximum security prison, and it's worth noting that our Court of Appeal opined in Canada here that it was clear to them that Dr. Diab would not simply languish in a French prison, but would proceed promptly to trial. Nothing of the sort happened. Exactly as we argued, he languished for 3.5 years in a French prison, while investigators, both of them investigative judges, concluded their investigation. They concluded there was no reliable evidence of guilt and substantial evidence of innocence. French media reported the investigators, quote, clearly believed Hassan Diab was innocent. They dismissed the case. Hassan Diab was freed and in 2018 returned to Canada. Never before had this happened in a French terrorism case. The French media reported that the victims were outraged. They wanted someone held responsible, and they continued to lobby for an appeal, which of course led to this appeal court and the judgment that came today. Importantly, the French investigators revealed previously hidden evidence. A, that contrary to what France had said from the outset, that there was no fingerprint left by the bomber on the hotel card, there was in fact a fingerprint. France misrepresented the truth to Canada, and that France also knew that they had compared that fingerprint with many individuals, including Dr. Diab, and he was conclusively excluded. That is not opinion evidence, that is scientific evidence. So even before France had come to ask Canada to extradite him at the request of France, they knew, the French, that there was fingerprint evidence that excluded Dr. Diab as the bomber. In addition, the French investigative judges revealed in their report dismissing the case against Dr. Diab that multiple fingerprints were left on the bomber's police statement when he was briefly in police custody in Paris. Canada, during the course of the extradition proceedings here, had France send the bomber's police statement to the RCMP for fingerprint analysis. All of the fingerprints on the bomber's police statement excluded Dr. Diab. Privately, Department of Justice lawyers told the French in correspondence that this was powerful, if not conclusive, evidence. The Canadian judge, however, was not told this during the extradition hearing. And Dr. Diab was extradited to France, with Department of Justice lawyers in Canada urging that the case was reliable enough to go to France. The French repeated the fingerprint examinations on Dr. Diab's arrival in France with the same conclusion. Dr. Diab was conclusively excluded. He was not the person who left the fingerprints on the bomber's statement. And thirdly, the French investigative judges produced independent evidence from the University of Beirut, both in the form of witnesses and documents, proving that in fact, Dr. Diab was, as he had always said from the outset, at the University of Beirut writing his exams when the real bomber was in France in late September or early October of 1980. The French appeal court has had this case on appeal for over 3 years. Even the appeal court tried to shore up the handwriting opinion, asking for these fourth and fifth handwriting experts to opine. You must understand there are only 3 new things in evidence from the point in time at which the French investigative judges dismissed this case, calling Hassan Diab clearly an innocent man. First, that Hassan Diab, in the latest handwriting report, has been excluded as the writer of the only cursive writing part of the hotel card, the date. And the French case proves that the bomber himself wrote the date on his registration card. Hassan Diab did not write that date. Second, as to the block printing on the report, where all the previous French reports preposterously claim that Hassan Diab was the author and identified as the author, this report says no conclusion can be reached. He can't be excluded. He can't be included. It's an inconclusive report because this is block printing. Millions of people in the world could not be included or excluded. It is not cursive writing. There is therefore no longer a French claim of a positive identification by handwriting opinion. That has disappeared. The entire basis for the Canadian extradition has evaporated. And third, what the Department of Justice lawyers called the smoking gun that justified a Canadian judge to extradite Dr. Diab has been ruled methodologically unreliable for use by France. So where are we today and why is this such a travesty of justice? The French appeal court suggested that Hassan Diab be put on trial in France anyway, so that the victims could have a trial. It's worth noting, the media have reported at the hearing recently of this appeal, the General Prosecutor's Office maintained its requests for reversal of the dismissal while admitting doubts about the presence of Mr. Diab in Paris on the day of the attack. They admit that they doubt he was even there, yet they say that the body of evidence, such as it is, deserves to be debated in a trial court. I respectfully submit that no justice system worthy of its name offers an innocent scapegoat to satisfy a demanding lobby. The prosecution of a demonstrably innocent man damages the credibility of France's justice system. This is a case like the infamous Dreyfus case, where France is not distinguishing itself. The prosecution of a demonstrably innocent man greatly benefits the real perpetrator or perpetrators of this heinous crime. Now they can relax that someone has been fingered. And the prosecution of a demonstrably innocent man is no service to either the victims or to the French public. Since the Canadian Prime Minister in 2018 on Hassan Diab's return to Canada told the Canadian public that what happened to Dr. Diab never should have happened and should never be repeated, not only is there no new evidence of guilt, there is additional overwhelming evidence of innocence. The only new evidence in this case points out even more strongly the innocence of this man. One, the fingerprint on the hotel bomber's card is not Hassan Diab. Two, the fingerprints on the bomber's police statement are not Hassan Diab. Three, the third French handwriting report, the Basadi report that justified, according to a Canadian judge, the extradition, has been identified by France itself as completely unreliable by being methodologically unsound. Four, there is independent evidence from the University of Beirut in the form of witnesses and documents showing that Hassan Diab was in Beirut at the university writing exams while the bomber was in Paris carrying out the crime. Five, the latest handwriting report excludes Hassan Diab as the writer of the date on the hotel card. It is not Hassan Diab. And six, the newest French attempt at a handwriting opinion destroys the sole basis on which Canada extradited Hassan Diab in the first place. At the most, it can be said it's inconclusive, but the methodology used by the prior handwriting expert was totally methodologically unsound. So we are at a terrible state now where a man, an innocent man, a demonstrably innocent man, and his family, who have been enduring this nightmare for 10 years now, is going to be dragged through a future of uncertainty, while for political reasons, this case marches on in France. Thank you.